works and why it works that way. That's all mechanism stuff. You're doing more of it than you realize. As long as like, I would encourage you to write the exam as if you're talking, you're explaining it to a lay person, like, someone, one of your friends who's called you for advice.
Okay, yeah. So, and somehow how you like taught it to us, like, this is the rule, this is why, this is what it used to be, maybe.
Yep, exactly. And here's why we do it this way. Because there's so many reasons why it's different.
All right, I'm trying to do my best on that one. I think a good amount of stuff. Okay. I gotta go back and I haven't looked at or reviewed the three kind of ways that unvested pensions or unvested things can be distributed.
Yeah, so we can do that right now if you want. The easiest part is that of the three, one is dead. So there's really only two left. Okay. So the one that's dead is the idea of like the court just figuring it out later and coming back in later and saying, well, come back in 7 years when the pension vests. We don't want to do that because that leaves courts with like indefinite jurisdiction, and it leaves the couples to sort of like stalk each other to figure out, is he still at the firefighting, is he still at the fire department, or is he gone? What's he doing these days? And so that one's dead. So then the only other two left are, to attach a percentage to it today and then cash it out 7 years from now. So we don't know if it's gonna be worth 200 or 2 million, but whatever it's worth, she gets 50% of it. And then the other option would be we're gonna actually attach a dollar figure to its worth today. So, he thinks it's worth 200, she thinks it's worth 2 million. We bring in these experts and they say 500,000 is the right number and she gets 50% of it. And so in the distribution of property, so maybe the house, for example, is worth 250. So maybe she gets the house because of that. So they'll try to like offset it today and cash it out using other assets, but in most situations there are not other assets to be had.
Okay, that's helpful. Thank you. And then I know I have this in a chart, and I need to pull out my charts tonight. But it's what Shanks, Simeon, and ALI.
Yes, yep, for prenups. And all that's the biggest jurisdictional split that still sits for the exam.
Okay, and then we went over Shanks last night, so that's at the moment of execution. Simeon doesn't care.
That's exactly right. So Simeon only cares about basic contract stuff. So one of the parties was drunk or under duress or under some sort of physical threat or fraudulently duped into signing the contract, but all like basic contract stuff. But it doesn't actually care at all about like the fairness side of it, like just getting it right. And the idea that if we accept this, we might leave one of the spouses to become a public charge. The court doesn't care about that. It says all that stuff is paternalistic and like super outdated.
And then the ALI, not at moment of execution, but at moment of dissolution.
Yes. Yep. Exactly. Or enforcement. So at the moment of enforcement would mean, okay, so say, you've been married 18 years, you signed this prenup 18 years ago, and, things looked a certain way then, but now 18 years later, we're going to do a quick fairness check to make sure we still feel comfortable holding this contract, term together. But the part that's kind of wonky about that, of course, is like, that's not a normal way to think about a contract. The whole point of a contract is to create, closure and certainty among, to manage risk. And so here, that's a pretty funny way to manage risk, to be like, oh, sure, you can totally protect yourself, but maybe you can't because if things change, the court might not accept it. So it's not very predictable.
Okay. Thank you. That helps a lot.
Yeah, it makes a big difference. And, Kentucky is closest to ALI. So it does look at fairness at the time of enforcement.
Okay, thank you. I'm trying to think of other things that may pop up. I think I can do EQD or equitable distribution pretty well.
Good. You guys did a good job with that yesterday. That was a great standout.
And so just to make sure that, I figure I'm just going to do it the way that we practice it, but you, so assume everything's marital unless we can pull it out, and then, but then do I go through each item? So say each item, and then say this is what it is, and then this is why based on statute, and then total each bucket up, and then okay.
Good, beautiful. That's exactly right. And then total each item up, and then keep going. And then what was the next thing?
I think that was about it. I knew I got to put the macro rule in first.
But once you've totaled them up, what do you do with the marital bucket?
Oh, and then we distribute it based on
Good.
factors, right?
Beautiful. If you can crush that question, you will be golden.
Okay, I really need to do that then. Okay, and then I'm sorry.
You'll be great. I was going to pep talk. That's all.
Okay. I love it. Then next big question: child custody. What are problems with that, or what should I think of?
For child custody.
Or maybe, so I always say child custody. I think I mean child support every time.
Okay.
I just always
say. Yeah. And we're going to practice it tonight, but why don't you walk me through tell me how you understand it first?
I typically just use the statute. But let me actually really remember. Let me look at my child custody statute.
Yeah, and we'll practice it tonight, but eventually my goal for you would be to be just as savvy on the equitable distribution as spousal support. Those are almost always the two biggest questions.
Oh, spousal support. Okay.
Yeah, child support.
Okay, so with the child support, I kind of, when I'm going through, I'm noting the incomes. But then there's other flags that the incomes bring up, and was that spousal support you were saying last night?
No, child support also. So it could be spousal support for the question of whether they can support themselves, whether they have the means to support themselves. But for our conversation now, it would all be relevant to spousal support. Exactly.
Okay, and then what we've seen a few times in the cases where like extraordinary medical needs or services.
Beautiful.
Like that.
Yeah, good. And so those would be a basis. And then what power does the court have in that process?
Okay.
How does that differ from the initial calculation?
I think I know the answer, but I'm not sure how to get to it right now.
Which one does the court have power in? Which one does the court not have power in?
Out of, actually, never mind.
Between the initial calculation of like how much support is owed and then the extraordinary medical and the deviations that you were just talking about.
Okay, so they have power in the extraordinary deviations.
Good. Yeah. Exactly. So the court on that part has complete power as long as it does what? How would, like if you were clerking for a judge who was doing a child support calculation, how would you have to handle a deviation? So if the judge said, I'm going to give this deviation because of this extraordinary medical condition, what would you have to do? Can you just do it on your own, or what would you have to do?
So the way you're asking the question, I know that you can't do it on your own, but what's coming to my mind is completely different. I'm trying to find it in my head, but because what I'm thinking of is the court order for the unvested thing, and that's completely off.
Yeah, so here it's just very, very simple. It's just that written findings have to be made showing that there's an extraordinary basis for a deviation. So not just like a small difference, like, your kid plays, in, what's it called? AAA ball and my kid plays YMCA ball, not like small stuff like that. Like it has to be like, something extraordinary. So not just your kid needs braces and my kid doesn't, like it's gotta be something really, really big.
Okay, that's cool. And are those usually given to us, those written findings, or do we just say that the court needs written findings?
You'll just say the court needs written findings, but you'll just have to set your client's expectations that those things may or may not be possible. Hey, DJ.
Thank you.
Hi.
Hi, we're talking about child support, like methodologies for how to answer child support.
Oh, fun.
But yeah, to be back to connecting it to equitable distribution, like the classification of equitable distribution is to the calculation of child support, contribution is to deviations. Meaning, remember, an equitable distribution with a two-step process, and the first step's mandatory, and the second step, the court has all that power. The same is true for child support, where in child support, the first step is super regimented by the federal government and the statute, and you'll get the same answer in Owensboro that you'll get in Louisville. And then the second part, the court has great discretion to make deviations.
That makes complete sense. Thank you for saying that.
But yeah, that's where like the great answers will pop on those points. And back to your first question, which was like, what are client counseling points? Those are the client counseling points. So like the fact that you can tell your client with 100% certainty that the initial calculation will be $1,281, but then you can't tell them whether college will be covered or not. That's the kind of client counseling that real people will value.
All right, awesome. Thank you.
Well, hey, DJ, did you have any specific questions you want to go over?
No, not really. No.
No. We're kind of just going through the same, like, Demetri and I are just kind of going through the big topics and making sure we got like the points. So we talked about equitable distribution already, and now we're talking a little bit about child support, and we'll practice that tonight too.
I'm just trying to do something that's not work. So.
Oh, yay! How's work going? Did you just started this week, right?
Last week. I worked 10 hours yesterday, but could only bill 6 of them.
That's very normal, but that's stinky. But yes.
Yeah.
So are you working in the office or at home?
We're at home.
Okay. That's even harder though, because like in the office, that's where FaceTime is like your friend, where people can see that you're there and active and doing things. But at home, I bet that billable hours feel way more oppressive at home because you can't. Can you even show it as non-billable, like training or CLE or something like that?
There's some stuff that you can, but like the remote desktop only had like 121 gigabytes for Louisville and Indianapolis office. So everybody that's on a laptop has to use the remote desktop, and there's like no space. And so we were basically locked out for like 3 hours yesterday, and then the day before that it was at least half an hour. And so because I work in like hard copies of everything, I was able to work, but it was a nightmare. So
how's it even working? Like you get an assignment and then like a research assignment or something? Yeah, I think it's huge because it because of the question of what the heck it means. So he uses dignity in 2 significant ways. First, he uses it in Gonzalez, which you may or may not have read depending on which book you have. But if you have the old book, he uses the dignity to talk about why we should all be so scared about abortion because of the way in which quote unquote abortion doctors are, the kinds of dignity, the lack of dignity that they bring to the medical profession. So he talks a lot about dignity there and like the way in which we should be more concerned about how quote unquote abortion doctors interact with their patients and whether they tell them about risks or not. But then he also uses dignity extensively in the Obergefell opinion to talk about the interest of the children in having a relationship with their parents and the dignity of being, the loss of dignity of being the child of same-sex parents who are not treated equally before the law and what that's like and the loss of dignity that creates. And so the reason why that matters so much in Obergefell is because of the parentage stuff from last week. So there are several courts, at least 3 that I can think off the top of my head. There are several courts that have taken the old traditional parentage laws like Kentucky has and said that dignity language of Obergefell goes so far as to strike down as unconstitutional a statute that wouldn't allow a same-sex partner to take advantage of the marital presumption. So it's really interesting. But he's gone now, and like the word dignity, dignity, Gorsuch didn't use the word dignity in his, transgender case. It's not in, medical services, so it may be a dead doctrine. But at the moment, what it suggested, I would describe it as a sort of, white picket fence sort of traditional version of it. But nonetheless, it got a lot of traction to strike down parentage laws and other things that treated same-sex parents differently under the law than opposite-sex parents.
Okay, thank you.
Yeah, it's a fun. I would say that you would never be wrong on the exam to not mention dignity, but dignity could be a cool portal to make some really, really good arguments on the case on the exam because every statute I give you is, probably unconstitutional, and that dignity thing is just like this interesting, like little umbrella that could fit a lot of things.
Okay, cool, thank you.
Cool. Lisa, you had a second question too.
Yeah, I just like this is a little broader. I have my weakest areas like how I feel good about everything else, and I'm having like a lot of difficulty delineating like when fundamental right would be the primary argument and when equal protection in the marriage cases specifically, because like I do think there's a right to marry, but also equal protection just seems so obvious for like not for same-sex marriage.
Absolutely. As a starting point for the exam, I would say that you should assume it's probably both always, unless you're really sure that it's not. And if there were only going to be one, it's always going to have to be an equal or fundamental rights question because that just gets so much more at the heart of family law. But you should assume it'll probably be both on the exam. I don't know if that helps you or not, but you're
yeah, it does. I sort of like took that approach, but I just wasn't sure. Thank you. I think that wraps up all my family law questions. I think as far as I can think of.
Okay, cool. And if we want to do a practice combo question, like I'm happy to stay. Like I did one with Demetri and Juanita a couple weeks ago, and I think it was like minutes. You might have done that too. It was only like 20 minutes. But we can always issue spot like a quick one. I can pop it up now, even if you guys are, if you want to, just chat one out.
I'm happy to do one after or like before, or we can like that would be helpful for me. But
Demetri, Liz, DJ, are you guys all cool with that too?
Can you repeat that? I'm sorry.
Oh, just throwing up an old combo question to talk about.
Oh, okay. Oh, yeah, definitely.
Yeah, so let's just take a quick look at this one. This is the one that we were doing yesterday. For those of you who were there yesterday, let's try to get it. It's a little better. This is the one we were doing yesterday. So let's just get sketch. Obviously there's no time to write, but we can just sketch out. So take a look.
I'm pulling it up real quick because I'm having the same issue as yesterday with the image appearing.
Oh, okay.
The
Protect Our Children bill one?
Yeah.
Okay, thank you.
This is hard because I'm so pro-vaccine, but I think this is a very good bill. Is that word Alamo?
What's that?
Is in the like last bullet point? Does that say Alamo? Like, is that the word?
Oh yeah. Yes. Yeah, like you're holding your ground and like your last stand in your military battle. You're
Okay, like I don't think I've ever seen it written out like that. I'm literally just pronouncing it Alamo.
Remember the album?
yeah.
And I googled it, and it was like all the Texas stuff, and I was like,
Yeah,
oh,
no, it's used as like a last stand. Like I'm gonna fight to the death on this hill.
okay. I clearly do not have a history degree.
Well, it's clearly it's very fitting for the non-vaxxers. I myself haven't read this super quickly, but just at like a skim for exam purposes, which of the two fundamental rights or equal protection would you start with?
I would say fundamental right to parent.
Absolutely. And so anytime you read it, look for both, but one should scream out at you as falling above another. And so here, this is unequivocally a fundamental right to parent. And let's just throw out some of the names of the cases you would want to stick to if it's a parent case. What are a couple of cases we talked about that you want to touch on here?
Oh, I have my list. Hold on.
One starts with an M, doesn't it? I forgot.
Yep, Meyer, good.
Meyer, yeah, Nebraska.
Yep. So those,
Can you-
yep, good. Meyer Pierce, and I would add maybe Michael H. to this, maybe Troxel as well from this week, actually. But the key point here, though, parenting is a fundamental right. Fundamental rights, we need a compelling government interest. Why does the government, Liz, say it's a compelling government interest here?
Because it's a public health concern.
Good, perfect. And you would just pull out as specifically as you could just whatever examples I've packed in there. And then do you guys suppose that it is compelling government interest to do public health initiatives to incentivize vaccinations?
Yeah.
Yes, easy. And then the next question is, are the means selected here narrowly tailored? And that's where, like Liz was saying, I might have a hard time with this. That's where, like, the first part is, I think, is probably harder. But then we start to look at some of the data about who's vaccinated and who's not. You might start to feel you can make arguments about who's swept in, who shouldn't be, and who is left out, who should be in. So, the key point here is that hinging vaccinations on a custody determination is kind of like, putting the horse after the cart, because the other way around. I think that's right. It's kind of, out of order, because you're suggesting, that means only by then the children are in some sort of a legal dispute. And that means that any parent who doesn't go through a dispute with their other parent will never get swept up into this. So you can see for a fundamental rights analysis, we want to chisel this like a statue, as like, as clean and chiseled as it can be. And that's way not chiseled enough if it's using just this one portal to get at it. Does that make sense?
Mm-hmm.
So my suggestion, I think people get more overwhelmed by the con law stuff than they should. You look at that, that's like an overwhelming amount of text. It's kind of a daunting amount of detail. But at the end of the day, even if you just look at it from like 8 feet back, once you see the word parent in custody, you know what the issue is. Like there's not a lot of secrets or hidden issues in the con law stuff. It's more about just having a methodology in place to thoroughly support and explain your conclusions. But try not to get, I feel like it's more of a mental block than an actual substantive block that most people have. And it comes from like just a swagger. Like just walk into this like, all out, like you are a con law scholar, and you're gonna look at this, and it's either gonna be a right to parent, it's gonna be a right to marry, it's gonna be a right to intimate encounters, it's gonna be a right to abortion. There's only like 5 things that can be, spot what it is and then follow it. But even no matter which 5 it is, you're going to walk through that chart with either a fundamental rights analysis or equal protection, do a strict scrutiny analysis. You stop and consider whether the means are compelling. I'm sorry, whether the purpose is compelling, and it probably is, and whether the means are narrowly tailored, and they probably aren't. So try to like walk into this with like your like biggest swagger you've got. You are a law scholar.
Would you also do an equal protection for this one? Like, say, people without health care? Or, like, what would you just stick to fundamental rights?
No. I definitely stick to fundamental rights, because that last paragraph, which you probably didn't get to, said don't do anything other than the family stuff. So don't go outside of that. But you would do equal protection still, because remember, an equal protection claim is just a classification. It doesn't have to be a protected class. So here we're definitely treating non-vax parents with a custody dispute differently than non-vax parents without a custody dispute, or we're treating vax different from non-vax parents. And so, that's definitely a classification. What it's not, though, is anything suspect. So there's no inherent, when we're talking about like a suspect class, we're looking for, an egregious history of our country discriminating against this community or this classification. And so we have that with race, we have that with national origin, we have that with gender, and we have that with legitimacy. Question mark, coming out of Boston, if you're curious, question mark whether we're going to do that for LGBTQ people, but for our purposes now, not an issue for our course, but just something interesting to think about. But anything else, there's tons of other classifications in the law, tons and tons of them, but they just don't raise heightened scrutiny, and then they just have to be like mediocrely good enough, and they'll pass. So this would probably pass on an equal protection grounds, because it's at least a rational way to do this, but it's just not a very good way to do it. So that's another reason to start with that fundamental rights analysis.
Okay, cool. I feel good about the con law now, I think. Thank you.
Good. Swagger.
I just have a question. I think I'm kind of confused, mainly because I just lack a general understanding of the English language. But when you say narrowly tailored, are you like, okay, so we're looking for it to be narrowly tailored, and in the situation that we just read, it's not narrowly tailored because it's like and it's because it's the non-vax parents with a dispute versus the non-vax parents without a dispute?
Right, so the narrowly tailored just means that whatever, so we said that the government's purpose was probably compelling to try to achieve public health outcome on behalf of incentivized vaccination. But in order to make it narrowly tailored, you can't sweep in anyone that doesn't need to be swept into that statute, and you can't leave out one who should be in. It needs to be like, a perfect fit. You need to think about like clothing, right? It needs to hang exactly right. No, what's his name? What's the press secretary guy's name in the suits that got made fun of for his suits?
Spicy?
Spicy, no spicy suits. So this is definitely a spicy suit, right? Where it's not hanging right. Like sure, it's kind of generally getting some people who should be addressed, and it might incentivize some people to vaccinate, but it's not a mandatory vaccination. It's not systemic across communities. It's definitely, it's going to catch some people. It's going to leave a whole bunch of people out. And so because it's a spicy suit fit, then it's not going to pass that narrowly tailored level of scrutiny. It needs to be really spot on. So think instead about, so I actually think it's easier for fundamental rights to think about all the statutes that are really narrowly tailored. So in contrast, think about the law that says that you can't enroll at JCPS unless you are vaccinated, and every single student has to send a verification of vaccination, and then there's a narrow exception for medical purposes, and I don't even know if Kentucky has this, but in some states have a super narrow exception for religious exemption. And that's a narrowly tailored law. If your goal is to vaccinate children, to vaccinate people, a requirement that before every kid starts a mandatory education program, they have to be vaccinated, that's a good fit. That's a...
Okay, because then it's just people, like, in general that want to have an education.
Exactly.
Since you have to be educated, whatever, like since you have to go to school, then you have to get your vaccines. Okay, but this is because it simply focuses on the fact that we don't know about these kids who aren't vaccinated technically unless they have a custody dispute.
Yep.
Okay.
Exactly. Or like another good example would be, if our goal is to make sure that everyone who marries has consent to marry, we don't want minors marrying, a statute that says no one under the age of 16 can marry unless they have the permission of both parents or they're pregnant, right? Like that's a great example of another great example of a narrowly tailored statute to achieve a compelling government purpose. So I think it's easier sometimes to think about it through what a narrowly tailored statute would be, because it's most statutes would be better than anything I'm going to do on the exam.
Okay.
Hey, Nathan. Hey, Allison. Talking about Sean Spicer here. Nathan, do you have a blank beer, point blank beer? Which way to go? Point blank.
Yes.
Do you guys deliver, like ship out of state, or do you have to stay in state?
We have to stay in state because of distribution.
Yeah. Do you guys have a mask law in your county for your brewery, or are you guys open back up?
No mask law for the brewery.
So we're going to rigorously use every minute that we have together tonight to focus on getting exam ready. And we'll end with my cheesy totes. Let me start. I want to make sure we don't rush through at the end any discussion of the exam. And so the first thing I want to ask is whether anyone has any questions about the exam itself, like where to get it, what's on it, what expectations are, any questions whatsoever about the exam. It goes live tomorrow, 9 a.m. It's there waiting for you. You use your anonymous grading number to get it. Or do you have that? I want you to go ahead.
I know I'm going to have a hard time finding that exam. Is there a link?
Yes.
Link? And also, always before, we had to download NAM4, do a practice test, and all of that. Is it still the link from last semester still good? The exam for?
Yes. So you will still, especially for anyone who had me for torts this spring, it's actually, I didn't even change the link in the question. So let me, I'm going to pop it up here real quick. But this link right here, after class tonight, I'll email it as a hyperlink, so you can access it, but you'll click right through there. And when you get in there, you'll see that there are a couple of options available for the summer class only. It'll look just like it did for spring torts. And then you'll enter my, your anonymous grading number. The only difference is, and I straight up misspoke about it previously, so it is a correction or a tweak. The only thing is that you'll take it right in the software. And I misspoke on that because I initially, earlier, I talked about you doing it in a word processing program, but you're not. So you're just going on there. It'll be automatically saving as you go. And you have 4 hours from the time you take it out. If you have an accommodation, your adjustment for the accommodation comes off of the 3 hours, not the 4. So that 4th hour, I'm just trying to give you guys time for the navigation of like multiple documents and being, not having the rigor of sitting in an exam room. But so you have 4 hours from you sign it up to get it back in. And it closes out at 5 o'clock on July 10th, no matter when you took it out. So really, the last time you could start the exam is 1 o'clock on July 10th in order to get the full 4 hours. The other thing I want to point out while I have it here, and unfortunately this is like the one spot that's crossing over, but this top paragraph that crosses the page a little bit tells you what jurisdiction you're in. So just make sure that you have those items flagged in your material. So you'll see the Family Support Act, that's your child support, parental kidnapping, that's your jurisdictional stuff, Supreme Court cases, model rules of ethics, that's your joint representation stuff. All the statutory provisions that were assigned in class are fair game to the extent we talked about them. If there's some like small narrow provision that we never went over together, don't expect to get tested on that. And then those uniform acts, the UIFSA, the UCCJEA, and the original Uniform Parentage Act. So make sure you take a look at that. But any other questions about the exam, what to expect? The other thing I would encourage, I'm going to offer just a couple quick tips for the exam. First, I sincerely hope that your plan between now and when you take the exam is to organize and strategize, not to cram. You guys know the material very well. This is not a situation, there's no time in summer class anyway, but you've worked way too hard to be doing any sort of cramming. What I think you should be doing is organizing your materials by topic area. So you've got your prenup chart, or you've got your spousal support rules, you've got your so when you see each sub question, you're ready to roll and you have those materials handy. Don't be flailing all over your computer trying to find these things. Also have a plan for time management purposes. It was written to be a 3-hour exam, and in any other world it would be. So what I would encourage you to do is to use that extra time for reading the exam and organizing, but I would calculate your time using 3 hours. So if you're figuring out what is 20% of 3 hours, I wouldn't use the 4 hour time because I don't want you to use that extra hour to be panicked and crammed in those last 5 minutes. Use that extra hour to read it calmly, to sketch out your answer, and catch up and go back and touch up. But don't use it. I wouldn't factor that extra hour in across the whole exam. I would consider whether you want to take it in order or go out of order. If you're a con law lover, some folks really love con law and just can't restrain themselves on the con law question. If you're that person, consider doing that last. Or if con law stresses you out and demoralizes you, don't do that. Maybe do that last. Give some thought. You can do it in any order as long as everything is labeled. For this, one of the things I talked about in the review session office hours yesterday is this idea of your fatigue. You should assume when you take an exam that when you begin it, you're at your peak, your prime, you're sharp, you're fresh, you're thoughtful about how you're writing things up. And for the most part, when folks end, even under the best of circumstances, they're fatigued. You're a little bit more likely to take shortcuts or things like that. So if you think about a typical first question is often a grounds for divorce question and it's worth 20 points. The absolute best answer on the exam will get 20 points. Realistically, most folks do really well in a question like that. The worst possible answer for a question like that might be 17 points. Right? Like that's not a huge spread. So if you have to rush and do that at the end, and that's your bullet pointed rushed question, you're gonna be in much better shape than if your last rushed question is a 70-point question, where the best answer might be a 70, but the weakest answer might be closer to a 57 or a 60. And that's where you really want to be strategic about your answers. So I would encourage you, if you're comfortable, if your big questions are property distribution or spousal or child support rather, maybe start with those and use that fresh rigor to work through so that as you're kind of rushing through at the end, you're getting smaller points and risking fractions of points instead of big bulky questions. The one thing I will say that many of you will not listen to me about, but I'm going to beg you to, I really strongly discourage any cutting and pasting. I do encourage preparing. So having your global rule on equitable distribution or having your global rule on spousal support, and we're going to practice that next. But cutting and pasting really is a mental shortcut, because what's happening is if you just drop that in, if you type it up thoughtfully, you're reminding your mind what you need to do in an equitable distribution analysis and what the steps are along the way. If you just paste something in there, ethically it's totally fine. But from a mental standpoint, the exams, I know in the fall when I taught this last, I know tons of folks were cutting and pasting it. They don't read very well that way. way. They don't read very thoughtful that way. They read very choppy because the difference between what you wrote at home thoughtfully, in 2 paragraphs is very different. And it's usually not, it's over inclusive. Like it's not on point to what you've been asked. So if you have, some extensive write up about or parentage and same-sex couples, but I don't give you a same-sex couple, then, your clients will be like, why are you telling me this? So I encourage you to be ready to write those things up, but I would take the time to write those rules out, word for word on the exam with a guide and a plan in place. The biggest things that I think, I've never ever graded a family law exam from one of my classes where folks didn't know the law. Everybody comes out of this knowing the law just fine. What separates the top answers from middle answers is very simply analytic abilities. So you want to follow it's very easy in family law where a word like cruelty sounds a lot like punch, and you think that they're the same thing. You say, well, there's grounds for divorce because she punched him. But there's a real definition for cruelty that you would state, and then you would apply it, and then a punch may or may not be cruelty. And so be really careful, because in family law, I think people cut a lot of analytic corners because some of the rules are more intuitive and more fact geared. So be really careful to follow your rigorous rule analysis, even if it feels a little tedious. The last thing I want to say by way of tips for the exam is the one thing we have going for us as a class is trust. The exam that is sitting there waiting for you tomorrow looks like every other exam I've ever given. The Cody and Sarah fact pattern is an old exam. It's self, so everything, you should not expect any surprises when you take the exam. It shouldn't be a party, right? But you shouldn't expect anything where you're like, what did she do? That was a bait and switch. Like everything you're going to do should feel exactly like what you've been doing all semester. My expectations for what you write are coming right out of those charts and right out of the client counseling we've done. So let me do a quick round of any more questions, tips, advice. What do you need? Anything you want me to do to customize an office hour or anything? Okay. Brian asked, sorry, there's questions I totally missed over here. First of all, the elevator is only open to the ADA people, not to any other ordinary lazy schmoes like myself. But the exam 4, you will be writing directly in exam 4, and that is a change. I misspoke earlier because I, in prior conversations, believed you'd be taking it in your word processor. But you will not. You'll be submitting it in exam 4. So you're perfectly welcome to work on it in whatever you want. But when you actually submit the exam, it will be submitted in exam 4, and you can print the document. You can print the document as well. If you do, it's a 6, I believe, page document, and the first 2 are the instructions. So you could probably skip those or have those already printed. How you download the exam, let me put this back up, just like you did in torts this spring. So right here is a link, and that's actually the same link that you followed in spring for torts as well. But you'll just click right there, and it will take you to the U of L's Extegrity site, and it's sitting there. And I'll be watching my phone carefully. If you have any questions, you can reach out to me, or you can reach out to Dean Becker as well. But you click right there, and you use your anonymous grading number to get it. Any other questions whatsoever? So the countdown starts once you've downloaded the exam. Exactly. And then, and you'll be able to see how much time you have left to get it back. And if you have any tech issues whatsoever, just make sure you preserve your work using, working with Dean Becker, because he's exceedingly generous in stopping the clock if you have any tech issues or restoring time. So definitely, reach out to him if you have any tech issues. Okay. Reach out if you have any exam questions. I don't get any of the exams until everyone's finished on July 10th. So I won't know whether you've taken it or not, but I'm just going to trust if you're reaching out. Of course, if you haven't taken it, I'm happy to help. I have my office hours end on Monday, but that doesn't mean I'm completely still available. I just didn't want to create the impression that you needed to wait too long to take the exam. Okay. So with our time left, we're going to review, we'll just do a little bit of final exam readiness on parentage, custody, and visitation, and child support. So we should move. Okay. So first question I want to ask is parentage. So very quickly, we introduced the original UPA last class, but when we were talking about it, it was sort of an open question of whether the original UPA would be tested or whether one of the more modern UPAs would be tested. So we know the original UPA would be tested. So let's just use Sarah and Cody briefly to practice understanding how we know who is a parent. So the original UPA, if you have the new book, is on page 436. Maybe someone can type in the messages what page is on if you're using the old book. But let's, thank you, Brian. So let's have someone volunteer to tell us how, under the original UPA, is Sarah a parent to Ruby, Jane, and Tate? This is the easy question. DJ.
She gave birth.
Good, perfect. It's super simple. The old UPA is very traditional. Really, the only reason the old UPA is even interesting is because it's holding non-marital fathers accountable. That's what it was designed to do in 1973. It was not designed to deal with the, all the reproductive technology that could emerge and all of family diversity that we have. It was very simply designed to hold non-marital fathers accountable. So nothing super interesting for mom. She gave birth to both kids, therefore she is the mother. And next, how is Cody a father to Tate? Anybody? Juanita?
Tate was born when he was married to his wife.
Good. So Cody was married to Sarah at the time Tate was born. That makes him the father. We don't actually care at all about genetics because it's 1973. So when you use this old UPA on the exam, put your 1973 hat on. We don't have DNA testing. We don't have all of the modern technologies we have now. So there's no genetic testing. He was married to the birthing woman. Therefore, he is the father. And what about Juanita or maybe Liz? I think you were about to speak. What about Ruby Jane? Is anything different from what Juanita told us about Tate for Ruby Jane?
Well, for Ruby Jane, he doesn't. He's not listed on the birth certificate. And he also doesn't hold the child out to be his own, so it's arguable that maybe he's not. But I think they were married. They were married when they were.
Correct.
So under the original one, it's likely that he would be maybe considered the father, just as, the presumption of that he is the father.
Beautiful. Good. Remember, the UPA is not romantic. It is not a beautiful document about what's good for children and what's good for fathers. It's about money and not much more. There are multiple ways you can become a father, and I hate to be so crass and disgusting about it, but think of it like fly sticky tape here. We are trying to get someone who will pay child support. We don't care that Cody does not want to parent, does not intend to parent, that might not even be in the best interest of the child of Ruby Jane. None of those are the question for parentage. The only questions that we care about for parentage are whether one of the presumptions is met. If one of the presumptions is met, it sticks and it holds until or unless there's a conflicting presumption. So in subpart B, it says that a presumption may be rebutted only by clear and convincing evidence if two or more presumptions arise which conflict with each other. The presumption on which facts is founded on the weightier considerations of policy and logic controls. So we don't care whether Cody is biologically the father. We don't care whether it's best for Ruby Jane. We only care that he was married to her at the time the child was born. Therefore, he is stuck to the UPA. He is a father unless and until someone else comes along. No one else is going to come along because no one else is the genetic father. No one else is going to come out either because the wording of it is that you receive the child into your home and openly hold the child out as your natural child. That's very traditional language. This is really talking about the father who gets duped, who thinks he's the father, but actually isn't. And we're going to allow that presumption to stick unless and until another father comes forward like a genetic father. But if a genetic father comes forward under the original UPA, it's not clear that he would win. It's only clear that the court would look at which consideration of policy or logic controls. So for Cody and the children, there's not very complex parentage questions. If this were a question on the exam, it would be closer to a 20 or 30 point question because you would know with absolute certainty that both of them are parents. If instead on the exam you were applying the original UPA and you had a more complex fact pattern, that would be like a same-sex couple or like some sort of artificial reproductive technologies or assisted reproductive technologies. And if you see that on the exam, the trick for your success is to remember that you're applying rules from the 1970s to modern families, in which case whichever party wants to push out the parent, they'll try to argue that these are really traditional rules and really limited, and whichever party wants to come into the parenting role will try to argue that these should be broadly interpreted without regard to gender. And that's the big open question that will have to be answered in the next couple of years in Kentucky is, even though our parentage laws are still gendered, would we allow a female married partner of a woman giving birth to be considered a legal parent? Because if you can't tell a client absolutely yes, what you're instead telling the client is that they need to spend the money to do a legal adoption. And so that's going to create a real disparity for the cost to become a parent. So Cody didn't have to pay $1. My husband didn't have to pay $1 to become a parent. But in that situation, a married woman married to a woman giving birth would have to likely pay to adopt if they couldn't be certain that the law would protect them. So let me stop and take any questions about parentage. We're doing an exam roundup, really focusing on getting exam ready. So parentage, we're applying the original UPA. It's very traditional. It's very unforgiving, and it doesn't give a flip about the best interest of the child. It's looking to hold non-marital fathers accountable. Elizabeth.
So this is a question about the flip grid we had to do with Patricia Partner and so with what you just said, when I answered that question, I was relying on kind of the biological presumption as to why Patricia would be able to assert rights, I guess, be able to petition. So was that wrong to rely on that presumption because they're same-sex couple, or?
No, that is exactly what you have to argue. You have to argue. I can't remember which.
Patricia Partner gave the egg, but she didn't carry the child or birth.
Yeah, so it's like almost a perfect raw on that that we had read. Stephanie case, I think. So I think that she would try to argue that under the provision and under the as her natural child, which she could do because natural in that context means genetic, and so that would be her argument. And then the birthing mother would argue that she birthed the child and therefore falls under that traditional presumption. The challenge that the birthing mother would make is she'd say the genetic mother can't be a mother under the holdout provisions in the statute or the marital provisions because those are supposed to establish fathers, not mothers, and that's exactly the question that Kentucky needs to resolve. So for your purposes, you would just make those two arguments and then push it to a court for statutory interpretation. Great question. Okay, any last questions about parentage? Okay, great. Let's move to child support then. We're doing our sort of exam roundup, and I want to talk about child support for Cody and Sarah as well. So the first thing that I want to do, we did this with equitable distribution as well. Is the sound messing up from me, or can you guys hear me okay? Okay, just post if it happens again. I may need to log out and come back. Okay, cool. Thank you. So what I want to do to start off on child support is do exactly what we did on equitable distribution. If you remember a couple weeks ago with equitable distribution, we stopped and we wrote our robust rule that we're ready to use as our roadmap to start our exam. So what I want to do is give you like 4 or 5 minutes again as well here. And what I want you to do in that time is send me a private note in which you articulate a macro or global rule that's client friendly, so don't paste the statute, explaining how the court is going to handle child support. So you're going to be writing up, we're going to do it for Sarah and Cody. So imagine you sat down tomorrow to take the exam and you're reading the child support for Sarah and Cody. What would you put in that answer? What macro rules? So don't start doing any math, no math whatsoever, but just what would you want Sarah or Cody to understand about the power of the state, who's setting the rules, how the rules work, how certain your answer will be. So take 4 or 5 minutes and everyone should be sending me a chat note that gives a global rule on child support. About half of the answers, so hang tight. But I just want to come back and give some global feedback. Overall, everyone had a good start to it, and maybe almost everyone needs like twice as much content. So give some thought to, if you're like, think about if you're the client in this situation. Let's imagine we're going in the order we went through the class, from equitable distribution to spousal support to child support. The level of predictability is so much higher here. For when I grade these exam questions, other than like rounding differences, within like $1 or so, every single one of your exam answers should be the exact same. Just like whether you're in Jefferson County or I can't think of another county, or Fayette County, whatever county you're in, you should get to the same result in Kentucky. And it shouldn't matter what judge you drew or what county you're in. So think about that. Think about the power of the state. In general, our entire theme of family law has been tremendous power of the state to rewrite contracts, to override deeds, to compel an ex to make spousal support for the rest of another person's life. That is an incredible amount of power. But here, there's arguably just as much power, but there's no discretion. Also, this is one of the only examples in all of family law where the federal government is telling the states what to do. So if you're representing your libertarian Kentuckian who says, I'm going to call my local assemblyman and challenge this is BS, the government shouldn't be in our lives like this. It's not a state issue. You're going to get the same answer in Tennessee and Maryland and Kentucky. So lots of important things to think about. With that in mind, I'm going to move to just another quick brainstorming, and I'm going to ask you guys to move into the everyone chat so everybody can see it instead of the private chat to just me. But I want us to just try to put ourselves in the shoes of Sarah or Cody. And I want us to think, if client counseling matters so much on the exam, what would Sarah and Cody specifically be upset about with this framework? So what you just wrote was the perfect legal answer, of how this works. Well, let's just pause for a second and reflect on what that means to Sarah and Cody. So in the chat bar, what I want you to do to everyone is make your first word Sarah or Cody and give a sentence or so about how they would react to this rule. Why would Sarah be upset about child support? Why would Cody be upset about child support? The answer is both of them are probably going to be upset by this framework, but for very different reasons. So let's tease a couple of those out while I respond to a couple more, and then we'll start our math. But don't start math just yet. I have no idea what I'm doing. Much nicer, more thoughtful terms. So the key thing that everybody might be missing is you should be using your intake memo. Remember, so who has that info handy that you can either post in the chat or share? So the question is, what we're trying to do is calculate each spouse's gross monthly income. So what we need to do is make every number that we have a monthly number. So there are some incremental math steps here. So we know we have 2 annual numbers from Sarah that we need to make monthly, and then we have 1 monthly number from Cody. And then we also need Cody's income, and that came from our interview with him. And so you would take his salary, which I believe was $70,000 annually with bonuses of $10,000. Is that what somebody put here? And that's what you would need as the annual salary. Yeah, the $10,000 bonus. Yeah. Good. So DJ tells us that he makes Liz tells us he makes $70,000 a year. That number actually increased. We see, and the increase is a little bit of a red herring. It would be more interesting if it decreased, because then we could consider imputing income, and he gets this $10,000 bonus. So exactly as Liz says, it's 80,000 divided by 12. You can do it from here. I know you can. Books are still working. Good. But what you should have done is you add the 7 and the 10, you get 80,000, you divide that by 12, you get the 6,000. You get 6,666, which I hope made you laugh given the religious connotations of this. I'm not good enough at math to have made that on purpose, but it's pretty funny. Then you subtract from that the $400 that he makes, that he owes because of the offset. So this, if we go back to our reasons why Sarah might be upset, this is another reason, because we're going to take care of his ex-wife before his own children. She is going to be upset about that. Good. So then his income comes down to be 62. I just lost my numbers. Hold on. 66, I think that's right. I just lost my numbers. Thank you, David. Yeah, $6,266. For Sarah, we add together her 8 plus her 30, and we divide that by 12, and she has $2,500 of income. The one other thing I want to note of monthly gross income, the one other thing I want to note for exam purposes, you might always get things that you don't know whether they're income or not. Almost everything is income unless it means tested public assistance, like poverty-based welfare. Other things that will very much upset your clients, like military pensions, personal injury settlements, disability payouts, maintenance received by a spouse, all of those things would be included. Then we add those two numbers together, and we figure out what percentage each spouse is contributing. And it comes out to be, I lost my numbers, about, I think it's not 71%. Somebody type in there what it is. It's almost 70-30, but not quite. Good, Teresa. Yeah. So like 66-34. And then you go to your chart, your total number, and you look up, and it comes out to be, sorry, like so many types in front of me, I'm losing my bearings here. It comes out to be about $1,476, and then you apply those percentages back, and then those are the numbers that each spouse is paying. Okay, so let me look. I have lots of individualized messages to respond to, but everything I saw, everyone was doing really well. Everyone's off by like a couple of dollars from one answer to the other, but otherwise exactly right. Let me stop and take questions on spousal support. Questions. Oh, thank you. So Holly, so Holly was clarifying the 33 and 66%. And then depending on whether you round those things, it'll change your numbers ever so slightly. So the final answer would be to take your award from the chart, and you would figure out what 33% of it is and then what 66% of it is. Good. Any questions about child support? I know we went through that kind of fast, and my sense is we were dusting off more cobwebs with that one than I was expecting, myself included. We're dusting off more cobwebs. So give yourself a chance before you go in to just get your notes all organized again about what you're doing on that and explain everything as you go. Questions. Okay, Ellen, yeah.
So would you recommend subtracting the previous spousal support, like from step 1, like when you're calculating his monthly gross income rather than waiting until after? Okay.
Yeah, that's exactly right. So you get him to the devilish number and then subtract that and then do the percentages after that. And that's going to skew, and it's going to upset Sarah greatly.
Perfect. Thank you.
Good. The next thing we would do, that would be our mathematical presumptive number, whether you're in Owensboro or Shelbyville or Etown, whatever you live, that is the answer for what the child support is. And then we would look for deviations. If there are any deviations, they would need to be in writing, and they would look at the statutes. Let me just pop that up real quick. And these are, there we go. These are the statutory deviations that you can expect to see. So you're going to come to your presumptive award first. And if there is a basis for a deviation, it's going to be because of extraordinary medical needs, extraordinary job training, special needs, extraordinary medical, extraordinary independent resources. Think they're like Justin Bieber or a trust fund or a young working child. Or the parent's own extraordinary medical expenses. And if the court makes a deviation, it has to do so in writing. That was the Turner case that you all worked with. So you're looking on the exam for something really extraordinary. And the best language to keep that in mind is something where the original award would be unjust or inappropriate. So that's pretty strong language that we're looking for. Any questions on child support? Usually this is the second highest value. For exam purposes, just focus on showing your work. If you make a math error, I will roll with you all the way to the end as long as you show your work. Okay, next, let's talk for a minute about child custody. Again, I'm doing an exam roundup, really focusing on the client counseling and the macro rule things that you'll need to know to apply on the exam. So I would love for everyone to do the exact same thing we've done for our other rules and begin by sending me, Annie asked, do we round up or round down? I'm not 100% sure. It actually is done through an electronic calculation using a computer app, and I don't actually know which way it goes, but go either way. Whichever way you go is fine, but it will only change your number ever so slightly. So I personally usually round down, but either way is fine. Okay, so the next thing we're going to do is write up a macro rule for child custody. Exact same thing we just did for parentage, exact same thing we just did for child support. So what I'm looking for is a nice robust paragraph where you are explaining to Sarah and Cody how child custody works. When you did your flip grids, almost everyone was brilliant, or not everyone was brilliant in articulating arguments for the client, but you jumped right in talking to the court and making your client's case. That's what you'll do in your application of this rule. But I want you to start by just explaining to your client and think about why this matters. There's no better way to reinforce why client counseling matters than this one, because your clients are dying for you to tell them that the court will not take away their primary custody or that they're not going to lose time with their children. They are dying for certainty on custody, and you cannot give it. And so this is a huge client counseling moment. You can give them a child support calculation on their very first day and feel really good about your accuracy. You cannot give them concrete clarity about what a court will do on child custody. So what I want you to do is take 3 or 4 minutes and write up a macro rule governing child custody. What would you tell Sarah and Cody about how the court functions? Don't make persuasive arguments for them. You did that in the flip grid already. We're focusing here on exam strategies. What would you lead with on your exam?
Damn it.
Factors to help us decide. And so we can look at the wishes of the child, the wishes of the parent, their relationship with others, the motivations of the adults in the case, the proximity to home or school. And so we just start together. That's what the 50-50 or the equal presumption means. And then we argue from there. But the lens through which the court will make its final decision needs to be a best interest of the child decision. So you should definitely take on your exam a couple of paragraphs to explain how this works. Why? Because your clients will be devastated if they are primary caregivers who have been working day and night raising their children to learn that the presumption is 50-50. Or your clients will be very excited if they have not been a 50-50 caregiver and they know that the starting point gives them even more time than they've been able to enjoy up until that time. But the key thing here is even savvy practicing attorneys are getting used to this rule. This is a brand new rule, the part about the presumption of equal custody. And it's quite notable. Many states have a presumption of joint custody, but that doesn't mean equal, that means shared. And so shared in many of your life experiences might mean every other weekend with a night in the middle of the week with the non-custodial or non-primary parent and the rest of the time with a primary parent. The idea that our starting point is equal makes Kentucky quite noteworthy. And I want you to consider carefully what you think about that, because in many family situations, that may not be what the family is used to, or there are very few families where 50-50 is sort of what the child has been experiencing up until that point. The second thing I want to point out for exam purposes, so the first thing is make sure you state a macro rule. The second thing I want to point out for exam purposes is make sure you engage in rigorous analytic reasoning here. So if I give you a fact and I say mom struggles with bipolar disorder, you would say that this is relevant because of subpart F, where the court considers the mental and physical health of all individuals involved, and the the other parent will argue that it's not in the best interest of the child because of that. Or if I were to say to you that mom travels for work, or that dad works, erratic hours, or dad smokes, every single factor that I give you, you need to tether to every single fact that I give you, you need to tether to one of these factors. So for exam purposes, child custody is almost always the easiest law that you get, but it requires the most rigor in your answers. Just state the rule, explain it to your client because they might be surprised and they might be off put, and then in your analysis, you're going to pull from the exam all the facts given you and analyze with those facts, making persuasive arguments. So the way I encourage you to write your exam answer is you make your best argument for Sarah, you make your best argument for Cody, the court, and your conclusion is that the court will decide what's in the best interest beginning from that presumption. So next, let me take questions on custody. Any questions on custody? Yeah, Ellen.
Sorry, I think my hand was up here.
Thank you, though. Any other questions on custody? This one should feel pretty good, but just make sure your rigor is in place to answer it. I also got permission from one of your classmates. I'm going to post here a sample answer on the child support. I feel like I kind of botched up walking through that. So if you're working in file, you can sort of check your work using that. Thanks to your classmate for sharing. And Monica, go ahead, question.
When we're explaining the reason why the presumption exists, when we point to the constitutional right of the other parent to rear and raise their child,
you could, or you could just say, you could just use that approaches to child custody chart and just say that between the choices, preference, policy, or permission, preference, and presumption, that we are the strongest in terms of a presumption. Why does that matter? Because it takes discretion away from the family court judges. So in Kentucky, with this rule, you will better be able to advise your clients what the outcome will be, but they just might not like what the outcome is, because it's a pretty strict starting point. Most judges are very used to having more discretion than this. The last thing that I want to address is the visitation statute, and this actually transitions nicely. To the visitation. So from Monica's question, was this because of the constitutional presumption? And the constitutional presumption is sitting here glaring in a visitation statute because it says that a parent is entitled. That's a constitutional entitlement to reasonable visitation rights unless it would seriously endanger the child's physical, mental, moral, or emotional health. And the court is going to be given great discretion to fashion a visitation order that meets those standards. And so you would be looking there, if Cody's smoking, you'd be looking for a visitation order. You would say, of course, he's going to get visitation, but we need an order to address smoking. Or if Sarah has residents coming in and out of the house, then we would need an order ensuring that they have limited access to the children. So that's what you'd be looking for in your visitation analysis, would be any facts that suggest that some reasonable provision is necessary to ensure that the kids are safe, but it wouldn't mean that the parents don't get custody of the children. Okay, so any questions, or don't get visitation rather, of the children. So any last questions on custody or visitation? And Hal, you're totally right. That's it with the two kids. That bumps us up to the 1476. I'm sorry. Okay, any last, yes, sorry, no, I have like way too many things going on with a million chats here. Okay, any other questions? Going once, going twice. Okay, well, I'm gonna end us with our toast, so put your screens on for real. You can hide during class, but you can't hide during our toast. Put your faces, your beautiful faces up. We're doing this, it's happening. Okay, hold on. Yay. It's really not going to show me your faces. There we are. Hi. Okay. Do you guys have like a drink reel too? Am I drinking alone?
I can get one real quick if you want.
Oh, yeah. Okay. All right. Well, I have one. So cheers up for, I've got one for all of us. Mine's kind of big. All right. But I want to say thank you guys for being on this incredibly fast, incredibly intensive journey this summer. I have really enjoyed the chance to work with all of you, to be the quote unquote guide on the side, helping you as you yourselves became savvy family law lawyers. Every single one of you throughout this class has brought an unparalleled work ethic. This is the fastest 7 weeks I've ever experienced. You guys worked so hard and were so incredibly collegial to each other. So I hope that you're leaving this class feeling exam ready, feeling bar ready, and feeling practice ready. I think I said this at the beginning, but I was not initially scheduled to teach at all during the summer. I cherish my summers with my kids and having more flexibility, but I was really emotional that this might be the last chance I get to teach a class at the U of L. As you guys know, it's been kind of a crazy geographic situation, so this is potentially the last class I get to teach, so this bourbon toast means the world to me, at least. I'll be at Baltimore next year. I'll have this email account, and I'm happy to answer, to be a resource, be a reference, to be a champion for all of you guys. This school of law is forever my home, no matter what happens next year. And I can't wait to see what you guys do with this degree, to see you guys running for office and sitting as judges yourself and running your own law firms. And if it's not obvious to you, let me say it explicitly. This legal community needs you more than ever. Your skills and talents. Our budgets are struggling. Our families are struggling. Our workplaces are struggling. The need for lawyers has never been greater. And the need for savvy, client-centered lawyers particularly has never been greater. And the need for leaders. So I cannot wait to see what you guys do with this degree. But I have a real toast, and it's really cheesy. So brace yourselves. All right, ready? So may your relationships always be retrievably repairable, and keep your Brandeis community uncomparable. May all your careers be in your best interest, but you and your clients shall never have intimate trysts. May all your dreams be narrowly tailored to achieving your most compelling goals. May your closets forever be stocked with the softest of toilet paper rolls. I hope that you'll always remember that telling clients property will be divided 50-50 is like torturing puppies, nails on a chalkboard, and dental drills all wrapped up in one. But 50-50 is a child custody presumption. That rhymes better when I practice it before. May you always consider both substantive and procedural fairness in all you do. May your savvy professionalism always be permanent, not durational, for a year or two. Finally, may you always create a rebuttable presumption of putting family, health, and community above all else. So let's wrap this class by raising a glass and toasting your fine ass selves. Yay! You guys are amazing. I'm going to stay on as long as you need. Cheers for real. And, but I'm going to reach out with any questions, exam ready. I'm here to help you all the way through to Friday, July 10th. But I'm going to stop our recording and just open it up to any chit chat questions for. Yay. It was recorded, Liz. Okay, any last questions for class, for the exam, for life? Oh, Mary Beth, are you still on here? Where is she? Mary Beth posted, I'm happy to do one. I did one before class with a lot of folks, so but I have one ready. So Mary Beth said, are we going to do a practice common law question? And but I wasn't recording it before, but I can do one right now if anyone wants to stay. Just drop a note in the chat if you want to stick around, and we can easily do that. Okay, cool. So yeah, let's just do one now. Let me make sure no one else has any other questions, and then I'll pop up on the screen a question that I worked through with the with folks before class as well. Dimitri, is that a wave? That's really sad. It's very funny that there's no alcohol emoji sometimes. Probably a good reason for that. Okay, let me put up a question. And we don't have to spend a ton of time, and it goes pretty quickly. So Juanita, for folks who were, and actually, and Mary Beth, the other day when we did the practice question in the office hours, that was yesterday. Doesn't that feel like a long time ago? I think that was yesterday.
I know.
That's crazy. Anyway, we skipped the common law question, and now this is the common law question from yesterday's review. Let me see if I can get it up here a little bit better. Can you guys see that okay?
Do you know what year this is from?
This is from 2015. If you can't access it, I can just email it to you real quick right now. Is it not coming? Is it not super obvious? Here, I'll email it. This is yesterday too. Okay, so you should have that now. I didn't send it to everyone. Let me know if anyone else on here wants it. Ellen, I think Ellen and Davis, do you want me to send it to you guys too? Or can you see it on the screen there? Actually, I'll just send it to you either way. Okay. Oh yeah, you have it from yesterday. Okay, Davis, I just sent it to you too, and I apologize. There's like no pleasantries whatsoever in that message. Okay, but that way you'll have it for the just in case for later. Okay, so let's just take 5 minutes and don't focus on writing anything out. Focus just on organizing your thoughts following our methodology. So our methodology would be to ask if this is a fundamental rights issue, is this an equal protection issue, or is this both? And if it is both, where would we start? Which one is more important for time management purposes? So let's take 5 minutes, and I would love for at the end of this you just have a small outline of what you would say on your exam. Don't write anything out. Good, beautiful. So everybody's got it. This is screaming out fundamental rights. Next question, just to follow up real quick. What fundamental right is it? It's screaming out, but let's make sure we say it. Good. So this is primarily a fundamental rights issue. And then maybe, I like how Mary Beth words it. She says maybe then also an equal protection issue. But if it is an equal protection issue, it's definitely not the dominant issue. It would be a quick finale point. Juanita tells us next that the issue, the fundamental right at issue, so the first thing we would do is name the fundamental right, is the right to raise and rear one's children. And next question for our chat bar, what are 3 or 4 cases you would want to cite in answering this question? We sort of kind of think of these as little pods of cases. Which pod of cases are you going to want to cite here or gesture to on the exam for the proposition Juanita gives us that the right to raise and rear one's children is a fundamental right? What are some of those cases? Not custody. We were going way back now to the beginning. These are actually kind of spread out throughout the course, but we definitely covered a couple that talk about the rights of parent, including one that you read this week, so you might not even gotten to it. So I guess they are custody cases in a sense, actually. Somehow. So we would cite, good. So exactly. So Mary Beth is gesturing to the Troxel case, I believe. The right, yes, good. Troxel is the most recent case that you had. It's a great case to talk about here, standing for the proposition that you have that a fit parent has the fundamental right to raise or rear one's children. And notably here, the court is not declaring these parents unfit. It is instead creating a presumption of how to handle child custody. Good. So we'd cite Troxel. We would also go in the Wayback Machine and cite Meyer and Pierce, those very early cases talking about the fundamental right that set up our Griswold case. You maybe could also talk about Michael H., but it's not really that good. Okay, so we have a fundamental right to raise and rear our children. Next question, if we have a fundamental right, what standard of review are we going to apply to that? Let's chat about that. Good, strict scrutiny, perfect, which means we have 2 questions we need to ask. What are they? Or 2 steps to our analysis. What are those 2 steps? Someone throw up a hand or drop it in the chat bar. Good. So Juanita first tells us the first question is, does the government have a compelling interest to do what it's doing? And then Mary Beth and Davis both add, and the next question is whether the means that the government has chosen are narrowly tailored to achieving that government purpose. And so here, that leads us to, so step 1, does the government have a compelling interest? So the thing we need to pull out from this question is, why did the government do what it did? What is it trying to accomplish? So in the chat bar, tell me what the government is trying to do here, and then whether you think that's a compelling thing for the government to do. Good, absolutely. So we're going to really quibble on step 2 with the means chosen. But generally speaking, even if you're a huge proponent of vaccinations, or if you're super upset about anti-vaxxers, whatever your politics are, or you're an anti-vaxxer, whatever your politics are, it's hard to argue that the government doesn't have a compelling interest to protect children from the spread of infectious diseases. It might be controversial how the government is doing it, but the idea that it's a good thing for the government to do, even a compelling thing, is absolutely very likely. So that's our step 1. Most of the statutes you read will do well on step 1, either because it is a compelling government interest or because the court's not willing to contest it because it knows it's going to fail on the second. So then the next question is, are the means chosen narrowly tailored? And I think the key for success on the exam is to stop and explicitly say what the means are. It's super obvious. You're really just restating the statute itself. But what I want you to do in the chat bar next is tell me, what is the government doing here? How is the government using its power to try to get people vaccinated? And then we'll get near that to the next step, which is who's in and who's out. So the first thing is we're letting the government go, saying, sure, this is a great thing to do, but how are you going to do it? So let's stop and in the chat bar state explicitly what means, what method, what technique is the state rather selected to try to achieve this compelling goal of protecting the health of children. So you're really just reading the statute and summarizing it. So anyone, if you guys might still be typing, if not, feel free to just raise your hands. It's really just restating what the government's doing here. But I think it's a really helpful step because you can start to hear the disconnect when you say it aloud or when you type it out. Are you guys still typing? trying to read the room. It's hard to read. Okay, well, I'm not, there we go, okay. Good, so Mary Beth is posting, and it's really simple, like we're just restating, perfect. You're really just restating, but I encourage you to do it on the exam, because when you say it, that's when you really start to assess the fit. So the first thing it says, the real reason we're doing this is to protect children from harmful infectious diseases. But then Mary Beth says, the way we're gonna do this is we're gonna create a presumption that not vaccinating your kids means you don't get custody of your kids. And so like my first question, to the legislature here is, not one child is getting vaccinated because of this rule, right? So it's a very powerful goal that the government has, but at the end of the day, not one child is necessarily vaccinated at the end of the day. That should be your huge glaring horn that this can't possibly be narrowly tailored to achieving the goal of protecting children from infectious diseases. So now we're going to get to the question of whether it is narrowly tailored. And in order to do that, I think it's helpful to draw out ways in which the statute is ill-fitting. We were talking before class about this thing like the Sean Spicer fit. Remember all the like mockery of Sean Spicer in his suits that didn't fit? They're like hanging off of him. Well, this likewise is a poor fit for a statute. It's not really getting at what it needs to get at. So let's highlight why. So take a minute in the chat bar to offer just one critique to sort of blow up this statute and highlight the ways in which it's not doing what it's supposed to be doing. So you could highlight people who aren't swept in, who should be, or you could highlight people who are swept in, who shouldn't be, and then or highlight just the failure of it to achieve its goals. This is very easy to do. It just requires a little bit of articulating why it's such a bad fit. And she says, hey guys, people who are married, who never have a custody dispute, are never affected by this. So 2 anti-vaxxers married to each other will never be affected. 1 anti-vaxxer and 1 vaxxer married to each other will never be affected.